257. What is destructive trespass? It may be said to be any act committed by a stranger or volunteer upon the property, which if it had been committed by one in lawful possession would have been waste. CQ 254. The remedy at law in such cases is either trespass, Q, C, F, or if it amount to an actual ouster, ejectment, which will secure a person damages for the wrongful act. 258. What is a nuisance? Whatever unlawfully annoys or does damage to another, as an injury to realty. Anything that worketh hurt, inconvenience or damage. 3 Blackstone, 216. For other definitions see B and P. R. Company vs. Fifth Bapt Church, 108 U. C. 329, 1883. Company vs. Car, 38 Street, 453, 1882. Cooley Tort, 565. Bispham, 441. 259. How many kinds of nuisances are there? Public, or common nuisance, private nuisance, mixed nuisance. 260. Define each of the 3 kinds. The public is one where a thing is done which would annoy the general public, or the neglecting to do a thing which the common good requires, and law dict. And cases cited. A private nuisance is one where the act done or committed affects only an individual or class of individuals as distinguished from the general public, and the mixed nuisance is one affecting both the public and individual rights. 261. What is the remedy at law for public and private nuisances? For a public nuisance, in the nature of a criminal proceeding by indictment, or by an abatement by the proper public officer. And in a private nuisance, by an action for damages, or an abatement by the party aggrieved, if it can be accomplished without breach of the peace. 262. What is a patent right? A public franchise granted to the inventor of a new and useful improvement to secure to him for a limited term the exclusive right to make, use, and vend the article or object invented by him. Seymour vs. Osborne, 11 Wall, 533. 263. In order to originate the right to injunction for an infringement of a patent, what must appear? The validity of the patent itself, and the further fact that there has been an infringement upon the patent, and these facts must either be admitted or established by a common law court. 264. What is a copyright? The exclusive liberty conferred by common law or by statute on an author to print or otherwise multiply copies of his work. 265. Of what nature is the property of an author in his work before publication? It is absolute and perpetual, and is not lost by reading it orally, or even by sending it in a letter to a correspondent. All copyrights and patent right laws in the United States are based upon the provision of the Constitution of the U.S., contained in Article I, Sect. 8, Clause 8. 266. What constitutes an infringement of a copyright? The printing, publishing, selling, or exposing for sale copies of any work of an author, but the using of extracts or making an abridgment or compilation is not an infringement. 267. What are the 3 incidents for the equity for injunctive relief? 1. It attaches only on an admitted or legally adjudged right in the plaintiff which is admitted or legally adjudged to be infringed by the defendant. 2. It prohibits the continuance as well as the commission of a wrong. 3. It extends to an account of the defendant's profits. 268. What are the equities under the second division given by Mr. Adams, that is, where the courts of ordinary jurisdiction cannot administer a right? 1. For investigation of accounts. 2. For severance of cotenancies and other analogous reliefs. 3. Winding up partnerships, and administering testamentary assets. 4. Adjusting liabilities under a common charge. 5. The protection of the estates and persons of infants and lunatics. 269. Is the jurisdiction for account exclusive or concurrent? In most if not all cases, the right is equal in either court, but it is usually had in an equity court for the reason that it is more direct and easily administered. 270. What is the right of set-off? That right which exists between 2 persons each of whom under an independent contract owes an ascertained amount to the other, to set off their respective debts by way of mutual deduction, so as the residue only of the larger debt may be recovered. At common law there was no such right. And law. Dic. 271. What is the remedy at law on account? In ordinary cases, the action of a sumpsit for the balance, and in accounts between merchants, by the action of account. 272. What is an account stated? An account rendered by the creditor and assented to by the debtor, or where the parties have struck a balance of their accounts. 273. After an account stated, when may it be reopened? The court will never direct a stated account to be opened except for fraud or errors specified, and which allegation of error is not sufficient. Although an account may be surcharged or falsified, sometimes, when it is shown there is error in it. 274. What do you understand to be the meaning of surcharging an account? A surcharge is appropriately applied to the balance of the whole account, and supposes credits to be omitted which ought to be allowed, while a falsification applies to some item in the debts, and supposes that the item is wholly false or in some parts erroneous. If any of the parties can show an omission in a stated account for which credit ought to be taken, that is a surcharge. Or if anything is inserted that is a wrong charge, he is at liberty to show it, and that is called falsification. But that must be proved to be by proof on his side. Perkins vs. Hart, 11 Wheat, 256. 275. Define current or running accounts, mutual accounts, open accounts, account rendered. Current account, one which is being added to from time to time. Mutual, those having original charges by persons against each other. Open, one having items unsettled. Account rendered, one delivered by the creditor to the debtor as a basis for settlement. 276. In what does the equity for the severance of a cotenancy or other analogous relief originate? That the cotenants have a rightful unity of possession, and that its severance cannot be adequately effected at law. It applies most frequently as between co-owners, but the principle extends to suits for assignment for dower, and for relief against subtraction or non-payment of tithes. 277. Is the jurisdiction exclusive or concurrent? Because of the inconvenience of the common law writ of partition, a concurrent jurisdiction arose in equity, and exists in that court today unless taken away by statute. The statutes governing partition in the United States will be found in a note to Washburn on Real Property, Volume I, page 433. 278. On a bill for partition, how far will the decree extend? Not only to a division of the land, but if any of the co-owners has been in exclusive possession to an account of his receipts. The length of time for which an account may be had is usually 6 years. 279. If a ship be the subject of a tenancy in common, may it be partitioned in equity? No, it is incapable of compulsory severance, but a jurisdiction is maintained in the admiralty courts by which the majority in value or interest may employ the ship in any particular adventure on giving security to their co-owners to either return her, or pay them their shares. 280. In what does the equity for the assignment of dower originate? The unity of possession between the widow and the heir. 281. What is a partnership? The definition as given in Meehan vs. Valentine, 145 U.S. 611, is, that those persons are partners who contribute either property or money, to carry on a joint business, for their common benefit, and who own and share the profits thereof in certain proportions. A partnership can only arise by virtue of a contract between parties. 282. What is the difference between partition and the winding up of a partnership? The principal distinction is that in a partnership, each partner has the capacity to contract debts, and acquire assets for the partnership, independent of his individual debts and assets, the ultimate balance of which is a profit or loss. Because of this, an account must be taken before the individual interest can be known. These rights do not exist in cotenants. 283. How may a dissolution of partnership be caused? Generally, by the expiration of the time for the completion of the business for which it was created, by mutual agreement, by the declaration of one partner, by death, by bankruptcy, by the seizure of the interest of one partner on execution, by decree of court. 284. Does the equity for administering the assets of a testator or an intestate authorize a court of equity to try the validity of a will? It does not. Wills of personality belong to the ecclesiastical court, or those courts in the United States which have succeeded it, and wills of real estate to the courts of common law, unless changed by statute. See Schuyler Law Execut. Andadm, Croswell's Law Expandadm, Warner S. Am, Law of Adm, Andrews Am, Law, 1900. 285. When the validity of a will of personal estate, more properly speaking, a testament, has been determined by the ecclesiastical court, what evidence is admissible? A probated copy under the seal of the court, unless a loss or destruction is proven, is the only admissible evidence of the validity of a will, and the title of the executor. 286. A will is obtained by fraud on the testator. Does it create a jurisdiction in equity? No. It may, however, in certain cases where the fraud is against a legatee, give the courts of equity a jurisdiction to declare a trust in favor of the legatee who has been defrauded by the act of the drawer of the will. 287. What is the proper remedy for a devisee out of possession, seeking to enforce the will, or an heir out of possession, seeking to set it aside? An action of ejectment at law. For the common law courts only may try its validity, unless as before stated, but if there be some legal impediment, it may be removed by an equity court. Or, further, if either of these parties being in possession, has fear of a subsequent disturbance of his possession, he may perpetuate the testimony, or have an injunction to restrain persons who have brought repeated ejectment by filing a bill of peace. But the will cannot be tried in equity, unless it be so drawn as to create a trust. 288. What is the difference between legal assets and equitable assets? Legal assets are all those portions of the property of a deceased person, of which his executor or heir may gain possession and in respect whereof he may be chargeable by the process of the ordinary tribunals without the necessity of equitable interference. Adams, 252, Bispham, 531, Story, 531, and Law Dict. Equitable assets are those portions of the property which by the ordinary rules of law are exempt from debt, but which the testator has voluntarily charged as assets, or which, being non-existent at law, have been created in equity. Adams, 254, Bispham, 531, Story, 552, and Law Dict. 289. In administering assets, what is the rule of priority in an equity court? 1. Debts due to the state. 2. Certain specific debts, preferred by statute, to will. Ex. 723. 3. Debts by judgment or decree. 4. Debts by specialty, but if merely voluntary, the priority is only over legacies and not over simple contracts on a valuable consideration. 5. Debts on simple contract, i.e., bills and notes, agreements not under seal, either in writing, or merely verbally, or on implied promise. 290. Of what two classes are legal assets, either real or personal? And in case of trust, sometimes, by the statute of frauds, the trust is made a legal assets, so as to charge the heir in a court of law. 291. What are the two classes of equitable assets? 1. Real estate, devised for or charged with the payment of debts. 2. Interest, either in personal or real estate, which being non-existent at law, has been created in equity. Of this class, the principal one is an equity of redemption. 292. How may equitable assets of the first class, described in the question immediately preceding, be created? 1. By a devise to trustees, accompanied by a trust to sell or mortgage, or by a general direction to raise money. 2. By a devise that the estate shall be sold, which confers a power of sale on the person specified, on the executors, or on the court. 3. By a direction that the estate shall be charged, which authorizes a sale by the person on whom the legal estate has devolved. 293. What do you understand by the discharge of debts in pari passu? By equal steps, at equal steps, without preference or priority as of one creditor over another. 294. What is the manner of administration in equity? By a bill filed, by creditors or legatees, praying to have the accounts taken and the property administered, or, if neither of these is willing to sue, then by the executor, who can only obtain complete exoneration by having his accounts passed in chancery, and therefore is entitled to have it done. 295. What is the natural fund for the payment of debts and legacies? The personal estate, which should, as a general rule, be first exhausted even to the payment of debts, with which the real estate is encumbered by mortgage, the mortgage being considered but collateral security for the personal obligation. 296. What is the prima facie application of assets? 1. Personal estate, not specifically bequeathed. 2. Real estate devised for payment of debts. 3. Real estate descended. 4. Personal and real estate specifically devised subject to the debts by will. 5. Personal and real estate specifically bequeathed or devised subject to a charge of debts by mortgage, but only to the extent of such mortgage. 6. Personal and real estate specifically given, not charged with debts. Adams, 263. 297. What is contributor? The equity arises when one of several parties who are liable to a common debt or obligation, discharges the same for the benefit of all. Bispham, Sec. 328, Fetter, 253, and Law Dict. 298. What is exoneration? Wherever two or more parties are liable on a common charge, one of them primarily, the other secondarily, and the party secondarily liable discharges the whole, he is entitled to receive payment or be exonerated by the party primarily liable. 299. How do the equities of contribution and exoneration arise? Only out of contractual relationship, and never out of tort. 300. Can one by voluntarily expending money for another create in himself a right to contribution or exoneration? He cannot, except for the making of necessary repairs in cases of dwellings, storehouses, and the like. 301. If the liability arise by breach of trust not involving actual fraud, would the right to contribution exist between the trustees? Yes, although each trustee is severally liable to the Sestuique trust for the whole loss, yet they may have contribution between themselves, and if a third person has, with knowledge of the breach of trust, been benefited, the loss may be cast upon him. 302. Are these rights of contribution and exoneration recognized at law? Insofar as the machinery of the common law will allow, they may be enforced in an action, but the means of enforcement are very limited. 303. What is subrogation? It arises where two parties are liable, one primarily and the other secondarily, and the latter pays the debt. He is then entitled to be subrogated to the rights of the creditor, that is, stand in his shoes, as to the claim against the principal debtor. 304. What is general average? An illustration of the doctrine of contribution applying to cases where a ship and cargo are in peril, and a portion of the cargo is intentionally thrown overboard in order to save the vessel, when each person having an interest either in the vessel or cargo is compelled to stand his rateable share of the loss, proportioned to the value of his goods and the goods sacrificed. But general average does not apply in cases where the loss is occasioned by mere stress of weather, or where the sacrifice is made to save the lives or liberty of the crew. And Law Dic. 305. What is the equity of marshalling? It arises wherever the owner of property subject to a charge has subjected that property together with another estate to a paramount charge, and the estate doubly charged is insufficient to satisfy both claims. It is personal as against the debtor, does not bind the paramount creditor, nor the debtor's alienee for value. 306. Why does it not bind the paramount creditor? No equity can be created against him, by reason of the fact that someone else has taken an imperfect security. If the paramount creditor resorts to the doubly charged estate, the second creditor will be subrogated to his rights in the singly charged estate so far as to satisfy his claim if the fund be sufficient. 307. State why this equity is not binding on the debtor's alienee for value and with notice. The ordinary rule is that an alienee with notice is bound by all equities binding the aliener. But in this particular instance there is, or appears to be, an exception. because the creditor has omitted to take an express collateral charge, raising a presumption that he meant to leave the equities defeasible, leaving the owner with power to dispose of the second estate for value unfettered by his claim. 308. What gave rise to the equity of administering the estates and protecting the persons of infants and persons non-compass? To some extent it was provided for by the right of guardianship at law and could be carried into effect by the writ of habeas corpus in respect to the person, and by a writ of account as to the estate. But the methods by which equity protected the persons and estates were so much less involved that it is generally conceded that it is the best proceeding. 309. To whom does the guardianship belong? Of the person. During the father's lifetime, he has the guardianship but not the custody of the estate, and on the death of the father, the mother is the guardian of the person. This guardianship of the person is generally held to draw with it an authority over the personal estate. Kenscombe. Volume 2. p. 223. 310. What are the 6 common law guardianships? 1. Guardianship in socage. 2. By nature, applies only to heir apparent, is vested in the ancestor and continues until 21st year. 3. By nurture, which is of all the children, and not only to the heir apparent, and belongs exclusively to the father until his death, and then to the mother, and continues until 14th year of age. 4. By the custom of London, being vested in the mayor and aldermen, and continues until 21 in male, and 18 or marriage in females. 5. By custom of other boroughs and manors. 6. By the election of the infant. A guardianship by statute is the most important at the present time. 311. What is the proper mode of calling this jurisdiction into operation? By filing a bill to which the infant is made a party, constituting him a ward of the court, and afterwards any other matter may be determined on petition or motion. 312. What are the 3 principal incidents of wardship? 1. That the ward must be educated under the court's superintendence. 2. His estate must be managed and applied according to the orders or decrees of the court. 3. And his marriage must be sanctioned by the court. 313. In case the father be dead and no legal or statutory guardian, what proceedings should be taken? In such a case, on a bill filed, the court will appoint a guardian, and settle a scheme of education, and in doing so, will have regard to the wishes of the demesnes of the infant. 314. If a guardian is a non-resident, can he be removed for that reason? No, but it will be cause for the joining of another person resident within the jurisdiction, and who is responsible to the court in the guardianship maintenance for the ward. An absolute authority, and the maintenance allowed in general must be shown to come from a present income belonging absolutely to the infant, and that its allowance is for the benefit of the infant. 316. What is the mode of allowing maintenance? It is proper only to allow a specified sum annually, which is to be proportioned to the age, rank, and fortune of the infant, except on special grounds, when an extraordinary expenditure may be ordered. 317. Into what 2 classes may persons under mental incapacity be divided? Idiots, who never have had and are presumed never to be able to have reason, and lunatics or persons who have had reason, but because of misfortune, have lost that reason, and become incapable of managing their own estates. 318. On the death of a non-compass, does the power of the court continue? Only as to the winding up or settlement of the estate, and the committee will continue under the control of the court until the estate is delivered up to the person who is entitled, or where the lunatic or non-compass has not died, the estate is returned to him on his recovery. 319. Name the principal maxims of equity. 1. Ubique sibi remedium. Equity will not suffer a right to be without a remedy. 2. Equity follows the law. 3. Vigilantibus non dormientibus equitis subvenit. Equity aids the vigilant. 4. Between equal equities the law will prevail. 5. Equality is equity, or, equity delighteth in equality. 6. He who comes into equity must come with clean hands. 7. He who seeks equity must do equity. 8. Equity regards that as done which ought to be done. 9. Equity regards substance rather than form. 10. Equity imputes an intention to fulfill an obligation. 11. Equity acts in personam. 12. Equity acts specifically. 13. Equity prevents a multiplicity of suits. 320. Name the jurisdictional rules of equity. 1. Equity has no jurisdiction where the remedy at law has always been plain, adequate and complete. 2. Equitable jurisdiction is, in general, not ousted by a subsequent expansion of the legal remedy. 3. Equity jurisdiction, having once attached to a case, will be maintained for the purpose of complete relief through the final adjudication of all rights involved. 4. Courts of equity have no inherent jurisdiction in either of the following cases: first, to prevent the commission, or interfere with the prosecution, of crimes; second, over the election or motion and removal of public officers;